Hey everyone, welcome back. If you love learning about landmark cases and want to stay updated on key moment in law, you're in the right place. Today, we're diving into one of the most influential cases in tort law, White and Jones from 1995. It is a case that reshaped how we think about professional negligence and third-party liability. Grab your popcorn because this is a legal thriller, you won't want to miss it. Picture this. Mr. Barry White is an elderly gentleman. He has a falling out with his two daughters and decides to cut them out of his will. Harsh, right? But time passes, emotions settle, and eventually they reconcile. Mr. White wants to make this right, so he reaches out to his solicitor, Mr. Jones, a man he trusts, and asks him to change his will. Specifically, he wants to include each of his daughter with a £9,000 inheritance. Now here is where it all goes wrong. Mr. Jones says, "Sure, no problem," but then he does nothing. Weeks pass. 6 of them, to be exact. Despite Mr. White's repeated reminders, the changes to the will were never made. And then tragically, Mr. White dies before the will is updated. Then tragedy struck and Mr. White passed away. And because no new will was signed, guess what? The old will stands. The daughters, they get nothing. So now you have got 2 grieving daughters who were promised something by their father, and that promise was broken because the solicitor failed to act. But can they sue? After all, they weren't the solicitor's client. Let's find out. This brings us to big legal question. Can a solicitor be held liable in negligence to someone who isn't their client but was clearly intended to benefit from their work? Traditionally in negligence law, you only have a duty of care to those who you are in direct relationship with. Traditionally in negligence law, you only have a duty of care to those who you are in direct relationship with, like a contract or someone whom you have assumed responsibility for. So at first glance, the daughters shouldn't be able to sue Jones. There was no contract between them, they didn't pay him, they never even met him. But the problem is, if they can't sue, then no one can hold the solicitor accountable because Mr. White is already dead. So do we just let the solicitor off the hook? Or do we adapt the law to fit the situation? It was a legal head-scratcher of epic proportions. The case made its way all the way to the House of Lords, now known as the Supreme Court, and here's what they said. Yes, normally a solicitor's duty is owed to their client, but this case is different. Lord Gough famously said that it would be a lacuna in the law, a gap, if the daughters couldn't recover for a solicitor's negligence, especially when the entire purpose of the job is to benefit them. In short, even though there was no contract or direct relationship, the solicitor knew his actions would impact the daughters, so the court extended a duty of care to them. Boom! That's a legal precedent, so the daughters were able to successfully sue Mr. Jones for the £9,000 each they lost due to his delay. This case is huge in the world of professional negligence and pure economic loss. The case didn't just right a wrong, it fundamentally reshaped the legal landscape. The case established that professionals like solicitors, accountants, and architects owe a duty of care not only to their clients, but also to third parties who are clearly and foreseeably affected by their actions. White v. Jones showed that courts are willing to recognize duties owed to third parties, especially when the professional knows who will be affected, the loss is foreseeable, and there's no other way for the injured party to get compensation. Since this case, professionals, especially solicitors drafting wills, have had to be extra careful because their mistakes can hurt people outside the contract and for us law lovers. It's a classic example of the law evolving to meet real-world justice. All right, that's the case of White v. Jones, a case that teaches us 2 big lessons. 1, don't sleep on your responsibility, especially if someone's future depends on your action. 2, the law isn't set in stone. Courts can and do evolve to fill the gap. Now, I want to hear from you. Do you agree with the court's decision? Should professionals always be liable to third parties, or does that open the floodgate too wide? Let's get the debate going in the comments. Smash that like button. If you find this helpful, subscribe for more deep dives into the world of law and hit the bell so you never miss an upload. Thanks for watching, stay sharp, and I will catch you in the next one.